Yeah. So I guess I probably will just start with the beginning with Carroll and Sue, and then we'll talk about how we got to where we are now. Everyone's familiar with Carroll versus the United States. It came out in 1925. It's one of the oldest Fourth Amendment cases we have in the Supreme Court. It's not the oldest, but it is definitely one of the oldest. And it's frequently referred to the automobile exception as the Carroll doctrine. And if you ever said that, everyone would know what it is you're talking about. But it's slightly misleading because the automobile exception over the last almost 100 years has come to mean more than what Carroll initially said. So it's developed quite a bit since 1925. It's much broader in scope and in justification than the initial Carroll case. Carroll was based completely on the mobility of the vehicle, the exigency associated with searching a vehicle on the side of the road with probable cause, the fact that it was not practical for officers to leave the scene and go get a search warrant. They encountered Carroll's vehicle. They weren't expecting to find him, so they didn't have a warrant in hand already. So that it was truly an exigent circumstance type of a search, time sensitive, based upon the mobility of the vehicle. But since Carroll, there have been about 24 U.S. Supreme Court cases that have dealt with the automobile exception, and more. It's changed more. It's not just the mobility of the vehicle that justifies searching it without a warrant. One factor that's just as relevant, even probably more significant, is the reduced expectation of privacy that the Supreme Court has assigned to motor vehicles, beginning probably with initially with Coolidge versus New Hampshire, but it really started to get rolling in the 70s and then the mid 80s with culminating in California versus Carney, where the court said it's the reduced expectation of privacy associated with motor vehicles is an additional justification for searching a vehicle.
When you say reduced expectation of privacy, I don't mean to interrupt you, but just have a little banter back and forth.
Compared to homes.
Yeah, compared to homes or even the person or body, right?
So as far as the hierarchy of Fourth Amendment authority, as far as degrees of privacy protected by the Fourth Amendment, the home is it's at the top. Followed closely behind by the person, your body, yourself, and all the way down at the bottom is motor vehicles. You do have an expectation of privacy. It is a constitutionally protected area, but that expectation of privacy is significantly less than a home. They're normally encountered in areas, in public areas accessible to the public, so people passing by can see what's going on in your car. They're heavily regulated by the government. And also, you normally don't store extremely personal items in your car like you would in your home. These have all been justifications the court has used over the years to call cars or get to assign a reduced expectation of privacy to cars.
Cool.
So back to where we left off today with our discussion on the group is the mobility of the vehicle. The only significance of that now in the automobile exception is the fact, does it look like a vehicle that works? Does it have four wheels? Does it look like it has a motor in it? Is it apparently an operable vehicle? Not imminently operable, but does it look like a functioning car? That's the first test on Carroll, and that's it for exigency. That is the exigent component. There is no separate exigency required beyond the inherent mobility in a vehicle in general.
I'm going to jump in and just say, when you say a vehicle, are we talking about all vehicles with motors that accelerate and move?
Anything that's self-propelled and is designed or primarily used for transportation. The Supreme Court has only assigned decided cases under the automobile exception with vehicles like cars and an RV in Carney. But lower courts, federal courts of appeals, state courts have upheld searches of boats, motorcycles, tractor trailers, including the trailer, towed trailers, anything that is attached to a vehicle that is designed or is being used primarily for transportation. Warrantless searches have been upheld under the automobile exception. Yeah.
With a motor, though, right? It's not going to work for a bicycle.
Correct. Yeah, it's got to be something designed for self-propulsion. Although you could probably make some kind of an exigent circumstance argument for a bike.
Electric bike?
Perhaps, yeah. But it wouldn't fall under the true automobile exception, I don't think.
Okay.
Airplanes have also been upheld, airplane searches.
Mm-hmm.
So the cases we were talking about earlier today, Pennsylvania versus LeBron and Maryland versus Dyson, the court made it clear. It can't be interpreted any other way. They said categorically, there is no separate exigency requirement under the automobile exception beyond the inherent mobility of the vehicle itself. So the only thing else you need is probable cause and a right of access to the vehicle. And I guess I'll get into that in a little bit when we talk about Collins versus Virginia. Probable cause, and it looks like a normal functioning car, you can search it without a warrant under the Fourth Amendment automobile exception.
Right. So when you say that, what we're saying is there are some states that have parted ways from the Supreme Court of the United States and the Fourth Amendment and have made the restrictions or the rules more strict for police officers in their state, requiring them to actually stop minus inherent exigency and go get a search warrant for the vehicle without consent. Obviously, consent's an accepted form of, without a warrantless, to do a warrantless search. Some of those states off the top of my head, I know New Hampshire is one of them. We now have Pennsylvania. They reversed the ruling. New Mexico happens to be another one of them. And you know what? Actually, as a police officer in New Jersey, for the time that I was here, we lost our exception in 2001, and we didn't get it back till 2015. So I literally worked majority of my career, actually all of my career, without the automobile exception to the written warrant requirement, which at the time I felt was a pain in the butt. But what I found was it forced me to get my consent abilities very, very, very good. I could communicate well. I could almost guaranteed 99.5% of the time I would get consent. And I wasn't being deceptive. I wasn't playing psychological ploys. I merely explained what your options were and how it was going to go. And by the way, I wasn't afraid to call a canine, have an indication, and impound and apply for a search warrant. Subsequently, in 2015, we had it reversed back to what it was in 1981 in New Jersey. So we now have the automobile exception restored to the state with some caveats, but our caveats are not challenging or an extreme hurdle. I'm sure you've seen some of the unforeseeable and spontaneous. You've read some of that stuff. It's really almost the same, just about the same. So just so we're clear with everybody, if you're in a state, and you should know as a police officer whether or not when you develop probable cause in a motor vehicle stop or in a motor vehicle setting, whether or not you would need to apply for a search warrant. But you know what's crazy, Zach? I literally went to the academy, my third one, and I had no idea what to do in the state of New Jersey when a car smelled like weed. That's, I had really shiny boots. I knew how to do I could march like I was the Marine Corps drill team. I could run 6 miles, do 60 push-ups. I was there, but I literally had nothing. I had no idea what I was doing legally. Nothing. I didn't even know, what are you doing? We're stopping cars like it smells like weed. What do we do? I don't know. Field training didn't tell us. You know what I mean? Like that's what I was dealing with.
I don't understand how anyone can do this job successfully without having a solid legal understanding. I mean, you have to know what your legal authority is. That's just step one in every encounter. So that just baffles me.
Well, and think about it. The biggest problems we have in this profession, besides politics and poor leadership, which is really the top of our issues. But the second or third thing down is, how do we train cops to know what they're supposed to do legally? Literally, 99% of police officers come out of a police academy and have no idea what to do. They don't even know in simple situations what to do. And field training has failed them as well, because their field training officers were failed through the academy. It's just this over and over process. And I always remind people, it's not malicious intent on behalf of the police of how they screw up or why they screw up. It's a lack of training, a lack of education, a lack of understanding of what they can do.
Yeah, I don't think there's a lot of malice in our mistakes are not malicious. Yeah, they're due to a lack of training and understanding. Yeah. Mm-hmm. So I wanted to mention, you talked about state law deviations. This is a very important point. Obviously we get a lot of questions on the group about automobile exception, and I always try to qualify my answer under the Fourth Amendment automobile exception. Because most states, the vast majority of states, follow the Fourth Amendment automobile exception to a T. There are a handful, and you mentioned a bunch of them. I know Alaska is another one. I think Montana. The main deviations are Pennsylvania is probably the most restrictive in that you have to have a true exigency even to initiate the search. And I think there's a couple other states too. Other ones allow the search until the police get custody of the car, say arrest the driver or something like that. Then you would need a warrant. But it's just a small minority of states that do that. So our discussion today is about the Fourth Amendment automobile exception, bearing in mind your state may be slightly more restrictive.